who is Steve Cabot from McCormick, Cabot, Jenner, and Lou, and his full biography, again, is in the materials, but he'll be talking about the Public Records Act.
Good evening, everybody.
Good evening.
You have a disclaimer in the front of your materials, and I'm going to take it a step further. Lawyers can disagree, and they can interpret things differently. And what I tell you here on the issue of Public Records Act is my legal opinion to the best of my knowledge and ability. When you have a specific issue that comes up, you consult with your own counsel. And if your counsel gives you an opinion different than mine, guess who you believe? The one you're paying. So please keep that in mind. The California Public Records Act, which is found in the Government Code, is actually based on the California Constitution, which states that the people have the right of access to information concerning the conduct of the people's business, and therefore the writings of public officials and agencies shall be open to public scrutiny. There's nothing more significant in law than the Constitution. The only thing that supersedes the Constitution of the state of California would be the Constitution of the United States. So when the Constitution speaks, we listen. The law is broadly construed in favor of public disclosure. That's significant. When in doubt, you have to disclose. And if we on the government side take the position that something is not a public record and is not subject to public disclosure, it's our burden to establish why and to justify it, and if need be, to convince a court of that. We are obligated to maintain records and documents in certain specific ways, and generally to make those public, available for either inspection or copying by members of the public. Public record is very broadly defined, and it's anything that we prepare, that we own, we use, we retain, and it's not limited to the written document. Now, a couple important things that were just said in there that we retain. Certain things that we may go through in the normal course of events, and like working drafts of a document, we work on the draft and we toss it away, don't have to retain that. But if you do a working draft and you keep it in a file, it can become a public record. A record can be handwritten, it can be typed, it can be printed, it can be photographed, it can be photocopied, and most significantly these days, electronic files. And the one thing I'm going to touch on particularly here today, and I scream at my clients all the time about, is emails. I'm an old fogey. I use a different term in the office, but I am. And it seems to me that if I need to discuss something with you, I pick up the phone and talk to you. I don't have to send you an email, but in today's society, most of us send emails. Keep in mind, if I talk to you, there's no recorded document. There's nothing, because you're not supposed to be recording telephone conversations without disclosure. So there's no trail. But if I choose to send you an email, I now have a paper trail and an electronic trail. And believe me, it's very difficult to erase electronic trails. So I'm working on behalf of a client, and we've got a member of the public out there who's being very difficult about something. My client picks up the phone and says, do you know what that stupid idiot Steve Cabot is saying and doing? I can't believe he's doing this. We ought to never give him anything that he ever wants again. End of conversation. Guess what happens if you send me an email? You got attorney-client privilege, so maybe it can be protected. But if one employee sends it to another employee, if one board member sends it to another board member, you now have a document which is a public record. And I cannot tell you how many times when somebody comes in with a public records request, those types of things in email form show up and they embarrass the heck out of the employees and the agency. May not have a legal effect, but it sure is embarrassing. And I attend department head meetings for my cities from time to time. And we have some very frank and open discussions. And we may talk about the fact that what so-and-so city is doing seems stupid. Or what the county is doing that we don't agree with. And we'll make comments about individuals. Boy, you sure don't want those in a form where somebody gets them. So please remember when you send an email that it is presumed that somebody has a right of access to that and to copy it. And so don't put in email form that which you don't want the public to hear. If you walk away from my discussion tonight with anything at all, that's it. And as you saw on my first page, I've emphasized that. As a general rule, all public records are subject to disclosure. So we start the ball rolling from the idea that any document the public has is a public record and is open to the public to obtain a copy or inspect it. And then we have to look at specific exemptions from disclosure, and those are set forth under the Act. Again, as I said earlier, drafts of documents, notes, internal memoranda that are not kept in the ordinary course of business are generally exempt. Remember, if as the general rule, you put those things in the file, and they sit in the file, and then somebody comes in and says, I want a public record request, and I want to see everything in that file, you can't all of a sudden go, oh, wait a minute, those were not intended to be kept in the general course of business. Too late. Don't save them from the outset, or they're going to be public records. Records pertaining to pending litigation, to which your entity is either a party in one form or another, or where you've had a claim made against you, are exempt from disclosure, but only until the matter is finally resolved. And LA City, LA County, due to their size and a variety of other factors, they get sued multiple times a week, and in the course of a year, they pay out, I think I saw some data last week that it's either the city or the county has reduced in 2009 their payouts for settlements and lawsuits down to $123 million. Heck, it was about 150 before, so they're doing well. But once those things become final, then a lot of the documentation in there is subject to public disclosure. So you need to maintain those records. You don't have to disclose them while everything's going along, but when it's over, you may have some obligations. Most significantly, personnel and medical files are generally exempt from public disclosure. But the rationale is that the disclosure would constitute an unwarranted invasion of personal privacy. Once in a while, the courts will determine that something in that category, that area, is subject to public disclosure. The big one that we've dealt with over the years, and we've seen most recently, is salaries. An employee's salary is a public record and is subject to disclosure. We find usually that the newspapers, once a year, once every 2 or 3 years, come along and do a sweep. Let's find out. And when you have the city of Bell doing what it did, it becomes real popular for everybody to start asking that question. But those are subject to public disclosure. There are multiple other specific exemptions, but those are the major ones. There is one general one, which is a balancing test. The law says that an exemption exists where the entity believes that on the facts of the particular case, the public interest served by non-disclosure outweighs the public interest served by disclosure, the balancing test. I can tell you, public entities almost never win that balancing test. That balancing test is not this, it's about here with this being disclosure. Very rarely do you win that argument. There also are exemptions for records that are not to be disclosed because of other state or federal laws. The attorney-client privilege. You communicate with me as your attorney, I communicate with you. That's an attorney-client privilege. There's nothing that you will see in the Act that talks about that specifically, but if you go to other provisions of state law, there are specific privileges that say you can't get access to communications between an attorney and client. So therefore, that's privilege. For those of you, how many of you provide utility services? Big one for you to note and keep mind of. The name, address, usage data, and credit history of customers for utilities is not subject to disclosure. Somebody calls up and says, you know, Steve Cabot's running for your board, and I think that he wastes water, and I want to see his records of how much water usage he's had in the last couple of years. Sorry, can't get it. One of the other things that we see fairly often is some third party comes along and says, you know, we'd like a list of all your names and addresses and information about your utility customers, largely because they want that database to send out some kind of advertisement. Nope, sorry, you don't get it. When I was younger, my fingers worked a lot better than this. Next important point. Just simply because something is exempt from disclosure does not make it always exempt from disclosure. If somebody accidentally or intentionally discloses that which is confidential and not subject to disclosure, they may have waived forever that exemption, and it may become a public record. Now, a lot of questions come up, who disclosed it and under what circumstances, but the best example is you have a closed session meeting to discuss some litigation. The attorney that's meeting with you passes out a memo summarizing things. When I do that, I usually require to be turned back in at the end of the meeting to avoid this very problem, but suppose you don't. You take it home and you decide, you know, I have a friend who's an insurance agent and I want him or her to take a look at this. I want to get that outside view. Well, you've just taken a confidential document and you've disclosed it. And disclosing it to one member of the public means it's disclosable to all members of the public. So thou shalt not do that. An important thing to keep in mind, this is a Public Records Act that applies to records that exist, not to information. And that can be very significant. A member of the public calls up and says, I want to know the answer to this question. Well, if you have a document that provides the answer to that question, they have a right, and you have to treat it as a public records request. But if you don't have any such document, then you're not required. We're not the public library. You don't legally have to go scurrying off and gather all the information, call them back, and give them the answer. For any number of other reasons, depending on what you're asked, you may want to do that. You may think it's good public relations or customer service, but that's different than a legal obligation to do so. We are also not required to create a document that does not already exist. So somebody calls up and wants you to gather all the information over the last 5 years and tell you how many times you've been sued and how many times you've won, how many times you've lost, and what's the total amount that you paid out. Unless you've created that document previously, you're not obligated to go do that now. What you may have to do is go gather all the documents that you do have that somebody can look at and put all together and add it all up. But that's very different than having to create a document. If somebody requests a public record, or as a document as a public record, and that document contains information which is subject to public disclosure and which is not subject to public disclosure, then you have a couple of choices. You don't give them the document that contains both. You can either redact, black out, cross out that which is not subject to public disclosure, or you can modify the document and give them an amended document with just what they're entitled to. So somebody comes and wants the list of all your employees and their job titles and their salaries, and you have it, but you have it all with Social Security numbers. Well, Social Security numbers are not subject to public disclosure, so you have to go in and either black out all those Social Security numbers or take that document and somehow recreate it without the information that's subject to public disclosure. We are not required to provide a public record in a different form than that which we have and maintain. So if we have something in written form and not on a computer, not on a disk or such, we don't have to put it on a disk. And the flip side is if we have something that's in computer form, we can give the requester a copy of the computer information in a disk form or whatever that case may be, but we don't have to go put it on the paper and give them to it. I dealt with a situation fairly recently where somebody wanted a copy of some minutes. And what they actually asked for was a transcription of the tape of the meeting. We don't transcribe those. It was talked about earlier, you usually take those and you save them for 30 days, but whoever prepares the minutes uses those to prepare the minutes that are going back to you. So, okay, you want a copy of the tape recording? We'll go and we'll actually have somebody make a copy of the tape recording. Or do you want to, we're not obligated to make a transcription. And so you can't have that. If you choose to do that, that's fine, but there's no obligation to take what's on a tape and have somebody make a verbatim transcription of it. We are allowed to require the payment of costs for providing public records. Those were limited as to what we can charge, and generally speaking, it's just a reasonable copying fee if we're actually making a copy of a written document. And and that's it. Now, if there's exceptional circumstances where you have an extraordinary employee time to go find all these and put them all together, et cetera, you may be able to charge for some of the employee time, but otherwise not. If we have to go outside, as in the case I gave you before, where we have to go have somebody make a copy of a tape, we don't have the capability within the entity to do so, then whatever we get charged, we can pass on as the cost. You'll see that very often if somebody comes in and requests records of some documents you have relating to a construction, where you may have very fold-outs that are very lengthy, or a parcel map or subdivision map that's oversized, and you don't have the capability in-house to make those copies. So you have to go down to Kinko's or Steve's or whoever and make the copy. That's fine. Whatever they charge, that's what you can charge in turn. We have the ability, and I strongly urge you to do so, to require payment in advance before you provide the copies. So what you should do is you get a public records request. First thing is you make sure you understand it and that it's clear enough. Assuming that it isn't, you request clarification. Assuming that it is, you then determine, is it a public record or not? If it is, then what are we going to have to produce? Somebody wants a 400-page document. Okay. What is our standard copying cost? 10 cents, 20 cents a page. And multiply that by the 400-page request, you get your amount. You communicate in writing to the requestor and tell them you're entitled to this, it's a public record, but you have to pay for it in advance. It's 400 pages at 20 cents a page. If I do my math right, that's either $8 or $80. We're in government, what's one decimal point? Whatever it is, you notify them. If they don't pay, you don't provide. And if they do pay, then at that point you go forward and make the copy and provide it. Again, in the instance I cited earlier, before we made the copy, we found out what it was going to cost, notified the person, and when he or she decides to pay, if they're going to, then we'll have the copy made and provided to them. Now, we've talked up until now about obtaining copies. The Public Records Act gives the public a second alternative, which is to inspect. So somebody can walk in and say, I don't want a copy, but I do want to see these public documents. Again, you have to go figure out what the documents are, where they are. Do they contain information that is exempt from public disclosure? And so if somebody comes in and says, I want to see the entire file you have on the XYZ subdivision, and that could be fairly extensive, all right? We first have to have somebody from the agency go through that file and determine what's exempt from public disclosure. Then we can take that out of there, notify the person that the document is ready for them to inspect during normal business hours, make arrangements, come on in, and we'll let you inspect. I strongly emphasize the word strongly, suggest that you have an employee present when that occurs. Because if you don't, somebody can remove something from the file. You just don't know. And you have a right to have that somebody present. So if the request is to inspect, that's fine. They may inspect and then they may say afterwards, you know, I'd like a copy of these pages specifically. And that's fine, and then you add up the pages and you tell them it's going to cost X, and as soon as they pay that, you'll provide it. Occasionally, especially with third parties, like attorneys or insurance companies or such, they may send somebody there to make a copy. So they'll send a copying company. That's legitimate. Again, you have to go through the same process to get to what is considered part of the, which documents are public records. And you have a right to have somebody present while they make the copies. Since they're making the copies, you're not charging them. In order to respond to a request, you have to have a reasonably identifiable record. So there are times when somebody will ask for something and they don't specify a particular document. They're looking for particular types of information. That information may be present in certain documents that you have. We have the burden of trying to assist the person making the request to figure out what it is they're trying to find and obtain. But if we need clarification, we have a right to tell them, sorry, we don't quite understand this. Give us more information. Give us more detail. Are you looking for this? Are you looking for this? Are you looking for that? And then proceed. We are not entitled to require that a public records request be in writing. Somebody can walk in and ask. But again, where it's unclear what they're asking for, then you can either ask them to put it in writing so we understand it, or if they're not willing to do that, we would put it in writing to them and say, this is what we understand you're asking for. Is this correct? Before you go on. Generally speaking, we have 10 days from the time we receive a public records request to respond. Now, to me, response means figuring out if it's a public record or not, figuring out if we have the document or if it's just information, etc., determining the cost of copying, and then communicating in writing to the person and saying, okay, on June 15th you made this request, and we've determined that there's 47 pages at 20 cents a page, and so when you deliver us a check, we'll provide you with the copy. Does not necessarily mean that you have to provide the copy within that time. If what somebody is seeking is particularly complex or difficult, or many, many documents, we have up to an additional 14 days. It's not unusual for many public entities not to respond within that time frame. I've had public records requests that I have submitted to Los Angeles Unified School District that I didn't get response to for 6 months. I don't think they're doing it deliberately. I just think that's the way LA Unified operates. You can push them, and if need be, and if it's appropriate, there are legal remedies. Go into court to obtain those. But I don't suggest that you take 6 months to respond, but I also tell you that rather than meet that strict 10-day and then additional 14-day deadline, that you make sure you do it right. When we decide that something is not a public record that's been requested, we have to respond in writing. We have to specify why we believe it's not a public record. This is attorney-client privilege. This is personnel records, etc. And we have to provide the names and the titles or positions of the people responsible for making that decision. Usually it's going to be your attorney and somebody else. But it's not enough to just simply say, you can't have this. You have to explain why and who the person is that made the decision. Now, I'm not quite sure what that means from then on, because if they list my name and somebody calls up and says, I disagree with you, my answer is, you're entitled to that. Too bad. And if they call and say, I don't understand what you're saying, give me more detail, I may provide a little bit more, but it's not like they're going to get a whole lot more out of that inquiry. If we are obligated to make a disclosure, and we do not, then the person making the request has the right to go to court to get an injunction or to seek declaratory relief. The court can order the records be disclosed, and under the right set of circumstances can require that we pay the prevailing party's attorney's fees and costs. Happens occasionally, not that often. Again, I would emphasize that the Public Records Act is very precise and very technical. If you have a person on your staff who spends a bunch of time working in that area, fine. If you don't, even if you do, I would say, when you get a Public Records Act request, contact your attorney. I mean, the answer may be very simple. Oh, sure, this is a public record. Or it may be much more complex than that, and it may take some time to unravel and decide. This is an area that is getting more and more public airing these days for a variety of reasons. The city of Bell, et cetera, is not the least of them. But as people tend to get more discontent with government, they tend to ask more questions and they want more information and more documentation. And we are in the age of discontent right now as government entities. So we're going to see more of this. Any questions?
Getting to collect the cards.
I was going to say, do I get something special if I get no questions? Okay. I'll take the short one first, that may not be easy. Does a person have the right to remove documents from office for copying? Absolutely not. As I said, you can have a copying service come in, but those documents don't leave the office. I mean, if you need to have something copied, you may send it out of the office to do that, but the person making the request has no such right. Can a member of the public who has a current and active lawsuit against the district be told that the information requested must be approved by council, or that information will be provided at the next regular board meeting after approval at the next regular board meeting? Well, I'll give you the standard lawyer's answer to that. That depends. But to try and break it down, as I said, under almost any circumstance, you should consult with your counsel before you provide responses to Public Record Act requests. The fact that it's in litigation just heightens that need. And there's a real issue out there because you have a Public Records Act right to obtain documents, and then you have, in the midst of litigation, you have discovery. And the question is whether you have to use discovery because you're in litigation, or can you go Public Records Act request. Generally speaking, I take the position that if we're in litigation and you want documents that relate in some way to that litigation, you have a remedy, and that's discovery. Go use it. But if you're going to disclose, again, you've got those timelines to do so. And I don't necessarily know why you would deal with the issue of providing that information at the next regular board meeting after approval, in the sense that you should be consulting with legal counsel, and the board itself really does not play a huge role in deciding whether something's a public record or not and disclosing it. Understand, if a document is exempt from disclosure, the board, as a group, can decide, notwithstanding that, we're going to disclose it. And that's your prerogative. And you can do that. But an individual board member cannot do that. So if an individual board member sits there and says, I think this is a public record, and I don't care that the other 4 of you disagree, and I don't care that legal counsel is telling me it's not a public record, I believe it is, my conscience said that, I'm going to disclose it. Then they've disclosed confidential information and they've got problems of significant note. Can a special district utilize this present training handbook as a reference tool for disputes made by an employee or a public member pertaining to PRA or requests? Example, the 10-day wait period. Where is that rule in the Brown Act? Well, it's actually in the Public Records Act, which is not the Brown Act. The Brown Act's the public meeting law. But as I said before, and as you got that disclaimer, this is only general information. And so you should talk to your own legal counsel. And if you don't have legal counsel on a regular basis, and what somebody make a Public Records Act request that's really touchy to you, I know it's hard, especially in these times, but go hire an attorney to get that answer. So again, based upon the disclaimer, I've lost there she is, Kathleen. But I would say the first part of that is, can you use this as a reference tool? Yes, you can use it as a reference tool, but you can't quote to it. You can't say, I attended Government 102 and the attorneys there said, you can't have this. It's like, well, I won't go into the Attorney General. Is cost for attorney's review of a file passed on? No. How long do you have to keep public records before we destroy them? That varies tremendously with the nature of the record. I know that in the case of cities, the city clerks have a pretty comprehensive compilation of how long you have to keep certain types of public records. I assume the CSAC has the same. And I don't know, I would also assume special district, the special district association statewide has that. But a very complicated question. Some things you only have to keep for a limited period of time, certain things you want to keep forever. The examples, minutes or accounts receivable and accounts payable, et cetera, and agendas, I would keep minutes forever. I would keep agendas forever. Accounts receivable and accounts payable, after a couple of years, I don't recall off the top of my head what the statutory provision is, but there is a time frame for that, and then no, you don't have to. And it's depends on which side of the coin you're on. You can't win sometimes. If you keep records forever and somebody comes to ask for them, if you have them and there's public records, you've got to disclose it. So on that side of it, if something says you only have to keep this record for 3 years or 5 years, purge at the end of that time. And the flip side of that is, I can't tell you how many times I've been dealing with something and go, it seems to be that something relates to this that we did 8 years ago. Do we have that? And when you purge the record, there's no doubt about it, it'll be shortly thereafter that you discover you need to have it. But personnel records, a good example, police officer personnel files. You're only required to keep them for a certain period of time. And I strongly recommend to my police departments at the end of that time period, you purge them. If they're of no use to you, they really are, in that case, they're no use to you. And, it's hard to get access to police officer personnel files, but why would you have them around just in case? Somebody started to ask a question, then repositioned it. So, as a public employee, if a person asks me what my salary is, what should I tell them? I get back to, we're not talking about information, we're talking about records. So your answer is, if you want to tell them, you can tell them, but if not, then they have to make a public records request. And then you have to have a document that they can inspect or that you can provide, you can give them a copy of. I guess in the smaller districts where there's only 1 or 2 employees, you may see more of that. When you're talking about a larger jurisdiction in a big city, et cetera, they want to see everybody's. Not likely they're going to come along and ask for, well, maybe the city manager or such, but police officer Cabot, what's your salary? Yeah. Utility district exemption from disclosure. Board agenda packet includes list of customers' accounts only. For accounting purposes, to proceed with termination abandonment, is it okay to have addresses noted as well? When you say terminated, abandoned, I assume you're talking about cutting off service, right? Whoever that came from? Okay. Yeah, I've seen special districts that provide utility services, and they'll have some information on utility shutoffs, etc. I would, I think you want to be careful with that. I think that you can identify by address and not name. You can, that would be the preferred way. I wouldn't go into detail about what's owed and outstanding, but rather, service at 1234 A Street is delinquent, has been for 3 months, and our policy is to proceed to terminate. If you're going to get board approval for that, then that's the way I would treat it. If public documents are being requested or kept at the attorney's location, can the attorney copy and expense be forwarded to the customer? Well, I guess, are we talking about virtually all of the district records are kept at the attorney's office? Okay. Most of the records that I have as an attorney fall under attorney-client privilege in some form or other, and so we wouldn't be providing those. I maintain full sets of agendas and things such as that and minutes in my records, but you're not requesting them of me. You're requesting it of the public entity. So the request, if somebody called me and said, I have a public records request for the Furbish Community Service District, which you're the attorney for, my answer would be contact the secretary or the manager of the district. It's not my place to respond and give you public records, and it's not where you're coming from. If I hold on to some of your documents and your records because it's easier to keep them for me, because maybe you don't have an office, or maybe you don't have a very safe place to keep those records at your office, then that's a different story, and then they're not asking them of me. the district is going to come to me and say, you're holding on to these records for me and we need to provide copies of them. And so it would be, the copying cost would not change. I haven't figured out how I get to charge more for copying than you do, although some of you may think so when you see my bill. Any other questions? I will leave you once again. Emails are evil. And govern yourselves accordingly. Thank you.
This is the point at which we're going to take our break. It's about 10 after, so get up, walk around, jump up and do a few jump jacks, and we'll see you back at 7:20.